in the typical fashion, it would be the inclusion of things that may not be true. The driving or what was observed by the trooper, you're indicating was induced by law enforcement. I'm not sure that a vehicle facing the wrong direction on I-94 is a position of safety. I'm not sure the trooper's testimony would be necessary. Let's call the case of the People versus Aaron Williams.
Morning, Your Honor. Raymond Cook for the People.
Your Honor, Michael Vincent on behalf of Mr. Williams. Mr. Williams.
All right. And this is an evidentiary hearing regarding the motion to suppress.
That's correct, Your Honor.
All right. Okay, are we ready to proceed on that?
Yes. Just as a preliminary matter, I believe at the last, the last hearing, the defense asked that the people secure, I believe Angelia Hayes is the witness's name, is the girlfriend of the defendant that the trooper spoke to after the arrest. We were unable to get that witness's appearance today, so I have the trooper, but not that witness.
Oh, Mr. Benton, you're aware of that?
I was informed of that this morning.
Okay. Okay. Well, understood. I guess, do you want to proceed with the not having that witness, or? Well, let me ask this. That witness, at least as I understand from the motion, is part of all of this because of her relationship to the defendant.
Yes, and because of statements she made to the trooper after the defendant was arrested.
Right, but she's there. She's there because there's some relationship with the defendant.
Yes,
It's not like she was some person just standing on the side of the road and
correct.
was there.
It was a dating.
Okay.
I think we go forward today.
Okay. All right. Because I was going to say that it would seem to me that you might have well, depending on how the relationship turned out, you might have a better shot than David. But okay, if we can go ahead, we'll go ahead.
Call Trooper Lewandowski.
All right. Trooper, if you come forward and be sworn.
You can see, raise your right hand. To the testimony about to give be the truth, the oath.
Yes.
Facebook, first and last name.
First name is Anna, H-A-N-N-A-H. Last name Lewandowski, L-E-W-A-N-E-O-W.
O-W-S-K-I. Okay, got it. Okay. Go ahead. You may inquire.
Thank you. Good morning, Trooper. How are you doing? Doing just fine. Thank you for asking. Trooper, how are you employed?
I am a trooper with Michigan State Police under the Brighton Post.
How long have you been working for Michigan State Police?
A couple. 2 years.
Any previous law enforcement experience? On or about October 30th, so the night of October 30th going into the early hours of October 31st of 2025, were you on shift that night? At any point in time were you on or at or near I-94 near State Street? And at around 11 o'clock that night, did you ever have contact with some vehicles on the side of the road? Can you describe to the court what that how that contact began?
So I was traveling eastbound on I-94 State Street when I observed a vehicle, a black Ford Flex, parked on the right side of the shoulder, with a second vehicle, black Mazda, facing the opposite way of traffic. I activated my emergency lights and made contact with the occupants of the Ford Flex.
You said that these were on the shoulder. Were they entirely on the shoulder or were they on the road at all?
They were on the shoulder. Okay.
Both vehicles were?
Both vehicles.
And the Mazda you said was facing the opposite way. So would that be westbound?
Correct.
Why did you pull over or why did you make contact with these vehicles?
It seemed like I saw occupants outside of the vehicle. So a car assist I do on a daily basis. So I just to make sure no one needed assistance. Me.
Who did you first make contact when you arrived?
I made contact with 2 females. They advised that they were on their way home and they got a flat tire. Upon making contact with those 2 individuals, I learned that both females were either suspected or revoked.
At any point, do you have contact with an individual by the name of Aaron Williams that night? Do you see that individual in the courtroom today?
I do.
Can you please point to them and identify them by an article of clothing they're wearing?
Like,
The record may reflect this witness has identified the defendant.
Without objection, record will reflect.
When did you first have contact with the defendant?
I believe it was the initial contact. I observed him walking around the vehicle trying to fix tires.
When you say the vehicle, is that the Flex or the Mazda? Okay. At that time, was there anything about the defendant's demeanor or speech that made you suspicious that he may be under the influence of any sort of intoxicating substance?
No.
How much interaction did you have with him at that time? None? What did you do after you made contact with these two females?
After I made contact with two females, I returned back to my patrol car, ran them in lane. I then got out of my vehicle, addressed the situation with them. I made contact with the Mazda, which was occupied by was Mr. Williams and Mrs. Angelina Perry, who identified as Mr. Williams' girlfriend.
Did the defendant indicate how the Mazda came to be at that location?
He said he was coming from his home in Ann Arbor and was there to assist his girlfriend's mother.
Did he say who was driving that vehicle? Who was driving that vehicle? You said he was coming from Ann Arbor. Did he say when he left to come to that scene?
He said he was just got done watching a football game and was requested by his girlfriend to come to the venue.
Do you remember which football game he said he was watching?
Who? Dolphins versus Ravens?
So
I don't think I like either one of those teams, but whatever.
At what point did you become suspicious that the defendant may be under the influence of either alcohol or some other intoxicating substance?
when I returned back to my vehicle, I requested him to turn the vehicle facing the proper traffic. I returned back to my vehicle just in case I needed to block a lane off for him to do so. When I was in my vehicle, he got out and I observed him unable to maintain his balance with walking the roadway, which made me concerned. I got out, addressed the situation.
When you say walking in the roadway, how far into the roadway did you observe the defendant?
Over the lot line and triple
And was this before or after he turned the vehicle around?
after.
Okay. You said you addressed the situation. What did you do to address the situation?
I got on my patrol vehicle. I said, sir, walking the roadway. He then came towards me. I was talking to him. And that's when I started smelling odor of intoxicants coming from him.
How close were you to the defendant when you first noticed that odor of intoxicants?
Arms 5 feet away.
At that point, was there anything else about the defendant other than the odor and the walking that gave you reason to believe he may be intoxicated?
I was asking him simple questions and he was unable to give me, look at me in the eyes or answer questions I asked him. So based on those observations and indicators, it's when I started to get my reasonable suspicion of something.
What did you do after you became suspicious the defendant was intoxicated?
I asked him to perform a series of sobriety tests.
Which sobriety test did you have the defendant perform?
I had him do the first, the horizontal gaze and stagnus. Second, the walking turn. Third, one legs.
And I'm going to assume the court has familiar with those. I'm going to skip over a lot of the details of those for the purpose of.
For 25 years. Yeah, kind of. All right.
What indicators, if any, did you of intoxication observe during the horizontal gaze and the stagnus test?
Last pursuit, distinct in the same stagnus on a maximum deviation, and onset nystagmus prior to 45. I observed all clues in the defendant and had to remind him multiple times to follow my stimulus.
Why did you have to remind him multiple times? Was he able to follow the stimulus? What was he doing that was unable to follow the stimulus?
Just kept on staring at me, not following my directions or maps.
Okay. So he was looking at you, not the stimulus? What was the next test that you had the defendant perform?
The walk and turn.
And what indicators of intoxication, if any, did you observe during the walk and turn test?
Just stepped off line and missed heel to toe several times.
Do you know how many times the defendant missed a heel to toe step? Okay. And what was the third test that you had the defendant perform?
On leg stand.
And what indicators of intoxication, if any, did you observe during that test?
I observed him, set his foot down several times and sway while things.
What did you do after the conclusion of those tests?
After completing his interview and sobriety test, I requested him to submit to a PPT, in which he refused.
At that point, what happened?
After he refused submitting the PPT is when I placed him under arrest for operating while intoxicated based on my SSTs.
Following the defendant's arrest, did you go back to his vehicle?
Correct.
Were you able to see inside the vehicle at any point?
Yes.
When you looked inside the vehicle, did you observe any containers of alcohol?
I did not know.
What about in the surrounding area? At that point, who all was in the defendant's vehicle?
At that point, everyone was, the two females were in the vehicle in the back seat, and his girlfriend was also in the vehicle.
Did you speak with the defendant's girlfriend about the defendant's intoxication?
Good, object to anything, his girlfriend had to say that's hearsay. This is a witness, that they had an opportunity to bring to court today, and she's not in court.
Your Honor, I have two responses to that. One being that this would go toward, this entire hearing is about the officer's belief in reasonable suspicion. I believe this goes towards her belief in her investigation. And second, I think that this is a preliminary question for the purpose of admissibility of evidence. So I'm not sure that the rules of evidence and the rule against hearsay would even apply at this point.
It's clear hearsay, Your Honor. She,
Well, if it's being offered for the truth of the matter asserted as opposed to this trooper's state of mind and then her subsequent actions.
they address that. Would you mind if I sit down or?
No, that's fine if you say.
Obviously, if the truth of the matter is certain, why else would the trooper ask that question?
Well, I don't mean to make anyone's argument, but I can surmise it this way. The trooper observed certain things regarding this defendant. She then places him under arrest. She's continuing her investigation, and she's talking to those witnesses in terms of how she's going to then proceed. So,
My understanding that placed under arrest after the girlfriend was talked to.
it's not right.
That's not the testimony that
Go ahead, yes.
I placed him under arrest for operating while intoxicated. I placed him in my patrol vehicle. I then recontacted.
Yeah, so, because at that point, and again, to address your issue, and I know the trooper certainly can speak for herself, but I have 3 individuals now. I have 2 vehicles, but I have 2 of those individuals don't have a valid license and can't operate. So she's got to continue doing something.
I don't disagree with that, but I do believe this is another thing. Certain fact, it's not an evidence. She's not here. And we addressed that specifically the last time we were here to have this witness here, so we wouldn't have to deal with her. And I do believe,
But it's not being offered for the truth of the matter, sir. If the trooper, I might agree with you if the trooper had not placed him under arrest at the time, goes, speaks with her, uses that information then to decide, I'm going to now arrest. I might agree with you, but he's already arrested. So I'm going to overrule the objection. I'll allow it for that purpose.
Do you need me to ask the question again? Or-
Yeah.
Did the girlfriend make any statement about the defendant's intoxication that night?
She did.
What was that statement?
She advised that they were both at his, residence and that he was, alcohol prior to driving.
After that conversation, what did you do next?
I informed her that he was arrested for operating while intoxicated. And she advised, which I knew prior, that she did not possess a valid driver's license as well. So I then had to go on the steps to make sure that they were driven home by a valid driver.
Going back to an earlier statement or earlier question, you previously testified that the defendant indicated watching, I believe it was Ravens-Dolphins game that night. Do you happen to know what time that game started? I just asked the court to take judicial notice that that was a Thursday night football game started.
I'd like to check the judicial notice on what time the football game started or anything also about two teams I don't give a hoot about.
Well, is that last part of your objection? I mean, but well, I'm a Steeler fan, so I don't like the Ravens, but I think, I mean, I could take judicial note. What would be the relevance of me knowing the time?
It would go to the timing as for when the defendant was driving, because I anticipate there may be an argument that the trooper did not have knowledge exactly when he was driving. And so with the understanding he was watching a football game, knowing when that football game was on gives the court a time frame as to when the defendant would have left the house and began driving.
I'll overrule the objection. I'll allow it.
I believe I put in my motion, I'll put up here because I don't have the time. I think it was 8:15 p.m. is when that game began that night.
Got it. Well, what time was their stop?
11 o'clock, I believe.
11 o'clock. Got it. Okay.
I can have just 1 second to look at my notes, please, Your Honor.
May I further objection
Certainly.
that because the game started at that time, there's no proof that's what Mike Simon watching the game.
I'm happy to address that objection in argument.
I mean, like it was delayed and he's watching it later, or
I don't know what time he sat down and watched it. All right. Why does game start? Your time starts at 8:15, doesn't mean kick off. I'm not sure what the role of all this is either.
I think it's just to pinpoint there's information that the trooper received that he was watching the Dolphin Ravens game. The encounter on the side of the road is around 11 o'clock. So what the people are getting in and want the court to take judicial notice of is the start time of the game. Now, there might be argument as to what the court does with that, but what weight I should give it, because if it was delayed streaming, I mean, I get your point, but I would still allow it. Certainly, you can argue the weight that I should give it.
My basic argument was the relevance.
I think it can be relevant, at least as to time frame, so I'm going to allow it.
I think at this point I'd pass the witness.
All right. Cross-examination.
What day of the week was this? Thursday?
Yeah.
And what was the traffic like at 11 p.m.
Traffic.
light traffic? And read through the report, and I got the impression as you were pulling up, you saw Mr. Williams kind of walking around somewhat in the roadway.
Not at that point, no.
Okay.
That was. You want me to fully answer? That was after walking the roadway, after I requested him to flip around.
How did you know he was the driver of that car?
Of the month.
Yeah. And so you were close enough to ask him that question, correct? And you were how far away from him when you asked him to move the car? A foot, 2 feet? Close, right?
Oh,
And he's in the car, and as you know from your experience, is if somebody's been drinking in a vehicle, it holds the smell, correct? And you were close enough to talk to him, to instruct him, and he was close enough to you to respond, correct? And I noticed in your talk prior prosecutor asked you questions, you never indicated that he slurred his speech, correct? You never indicated that he didn't understand your directions, correct?
sure.
When he's sitting in the car, you ask him to move the car.
It's kind of similar direction.
He understood your directions, right? And there was another person in the car with him, correct? And you obviously should have been able to smell anything on him at that point, right? Because you're right on top of him. Okay, so you didn't smell anything on him? Did you have any suspicion that he might have been drinking?
No.
Yeah, none at all?
Point.
Okay, that's because he didn't slur his speech. He understood everything you asked him to do. He responded properly, correct? And I noticed in your report that there wasn't any problem indicated. He had to back the car up and then pivot around, correct? He had to turn around. He had to turn the car to face it eastbound.
It's a proper way of traveling, yes.
And I didn't read anything in your report that there was any difficulty him doing that.
He had a maneuver to.
So you would agree with me, he had no difficulty doing that. And it's somewhat of a difficult move, backing a car up on the shoulder of the expressway and then turning it onto the expressway. Now, you did not move your scout car, your vehicle, to block a lane or anything like that. I didn't read that in there either.
Maybe I included, I can't remember if I did or not. I would turn back my vehicle if I.
Okay, but you can't remember whether you blocked the lane or not. If you can't remember, you can't remember. And again, I already asked you a question, but there's nothing in his driving, nothing in his ability to move that vehicle off the shoulder of the road, back up, then make a complete turnaround to face eastbound. Correct? Did he pull his vehicle back up onto the shoulder?
Tires on the fall line.
He was off the roadway, correct?
Correct.
And you didn't notice any problem with any of this at all to indicate that he was intoxicated?
Correct.
Right. I'm somewhat familiar with the shoulder roads of 94, and they're sloped, aren't they? Not sloped down, so when the rain falls, it doesn't make puddles, it kind of drains off the side. Okay. So what is the shoulder of the road made of? Gravel?
No, it's concrete.
Concrete. This was at night, and he was on concrete, and he wasn't able. Now, you saw he wears glasses, right? What did you do about that? Did you have him take glasses off or leave them on?
He put them on, but I can't fall.
Okay. And you know the glasses would affect the horizontal gaze and astigmatus test, correct? You don't remember that? Okay. And he wasn't able to hold his leg up for any significant amount of time and have to put it down, correct? Did he ever stumble, fall against a vehicle? Did he fall down on the ground doing these tests? Where did you have him do the test? Between the two vehicles on the shoulder of the road?
I have in front of my patrol vehicle.
For your patrol vehicle?
Correct.
And that's with the overhead lights going, correct? And your spotlight is on, no doubt? The bright lights are certainly, your lights are certainly on, correct? So between your vehicle and the flex vehicle, you had them do these tests? The court, can you give me 1 minute?
Yes.
And I noticed in your testimony again, you did not indicate that he was slurring his speech or anything like that, correct?
Correct.
Direct asked and answered.
And,
I'll let it go. Go on.
and on doing these tests, he understood you gave him directions, correct?
Correct.
And he understood your directions.
I'd say no.
He didn't understand them.
Remind and ask him numerous times.
Okay. How to do these tests. Would you agree with me? These are not normal tests that people practice every day.
Skills.
Standing on one leg. When you did the walk and turn, you have the people stand in an odd position before they start. Would you agree with me on that? Kind of 1 foot in front of another and have to wait till they're told to move forward?
Correct.
All right. Thank you.
Can you redirect? I do have a question. So you had indicated they're at I-94 in State, so exit 177. Or, see, there's a lot of stuff I don't know. I don't know why I know that. Anyway, going eastbound, were the vehicles at the Cloverleaf, before the Cloverleaf, after?
We're like just past Anna facility.
So you're, okay, I got you. So,
We are in between Ann Arbor Lane and State Street.
so between 175 and State, you're going eastbound.
East.
Got it. Okay. Okay. Was it talked about or was it determined how the Mazda came to face westbound? Was that even? Okay. It was just, that's where it was when you saw it.
Correct.
Okay. All right. Perfect.
I have no redirect, Your Honor.
Anything else based upon the court's questions, Mr. Benson?
Following up on Judge talked about, it's pretty unusual to see a car up in the shoulder of the road facing the opposite direction.
Yes.
And it would be especially unusual to have this happen around 11 p.m. And you had no suspicion at all that the driver of that Mazda might have been drinking?
Sorry?
You had no suspicion at all that the driver of that, it was a black Mazda, if I remember correctly, you had no suspicion at all that he might have been drinking?
At what point?
At any point up to the moment you encountered him on that 11 p.m. I think it was on the 30th of October.
Sorry. What are you asking? Are you asking if yes, I observed signs of intoxication from the truck.
Okay.
Are you asking at what duration during my encounter with them?
No, you answered my question.
Oh.
No other questions?
All right. Thank you.
No redirect. Thank you.
All right. You may step down. Thank you. Any additional witnesses for the people?
No, Your Honor.
No, we have another issue now. You have to file a Frank's motion on a search warrant.
Okay.
Unless the court wants to have us deal with that now. I indicated in my motion, what that's. I didn't go into details.
Right, but I don't,
If the court wants to be on Frank's motion on that.
well, if it's necessary, I mean, what would be the basis of the Frank's motion?
Thanks for the Frank's motion, that I'm sure the fact that
Okay, so first of all, I do not have, and now, nor was it included in this motion or attached to the affidavit.
then I will draw my.
But typically with the Frank's motion, it's not the exclusion of things in that affidavit, but in the typical fashion, it would be the inclusion of things that may not be true. And then the court would say, well, if that's not true or suspect and I take that out, is there still probable cause?
I'll file a Frank's motion.
Okay. You know, I think in 27 years, I had maybe 2 Frank's motions. Then Sharon Moore's case comes. And now everybody threatens them all the time. But I'm an expert, so that's okay. Doesn't matter. All right. So you're gonna let's do it this way. Is there any additional argument on this motion?
Your Honor, the only additional argument that people have outside of what was prepared in the written response was that the trooper testified that there was no alcohol found in the defendant's vehicle or in the surrounding area. I believe that leads to that circumstantial case that people are arguing that the defendant must have been intoxicated prior to the trooper making contact with him on his way to this venue, and that under MCL 764.15, it was proper for this trooper to investigate and arrest the defendant, even though she never directly observed his driving. For those reasons and the reasons stated in the brief, the people would respectfully request this court deny the defendant's motions.
Your Honor, the vehicle, when the trooper encountered the vehicle, was in a safe position, on the roadway, was not in danger of doing anything. And matter of fact, the trooper thought it was fine for whoever this client built the vehicle. So there's no danger, there's no reason to arrest. One could argue that, but for being told to move the car, he would not have been arrested. Nothing would have happened. But the driving that's involved in this motion was driving that she induced. The trooper told my client to move the vehicle.
Yes, but
that's the driving she saw, and she testified she didn't like the way he looked when he got out of the car. And everything stemmed from him driving that vehicle. What for her asking, but for the trooper asking him to move the car and the subsequent actions after that, he would not have been arrested.
But okay, maybe, but I think that you don't go far enough with the but for, because but for the fact that the vehicle is facing the wrong direction on an interstate, the trooper would not ask him necessarily to move the vehicle.
But she did. But the trooper did. I'm sorry.
Yes, because it's facing westbound in the eastbound lane on a major highway.
I agree. Also, it could have been towed out of there, not by driven. And it wasn't done. And everything that.
But hold on, I get you, Mr. Vincent, but on what basis would the trooper say, I'm just going to tow your vehicle? What she does is, it seems to me, is say, you need to turn that vehicle around so that it's facing a safe direction on an interstate.
I'm not disagreeing with that.
Okay.
But the fact that she did that everything followed after that. Until she told him to move the car, for whatever reason. Until she told him to move the car. He was not under arrest, even though there's some indication, apparently, that you could smell alcohol on him.
Well, when
She's not, I,
close enough and he's out of the vehicle, yeah.
but to me, the car facing the wrong way on the expressway on the shoulder road would indicate something's going on. But yet, my point is that none of the testimony about his walking and everything else happened after he was told to move the car and turn it around. And the judgment made, there was no testimony that this was done poorly, any sign of intoxicated driving or anything else, but yet he was pursued on that matter. The vehicle was moved from a position of safety by the trooper. My argument was,
Yeah, but hypothetically, and that's really what you're arguing. One might think that if the vehicle had been facing the correct direction, that the trooper wouldn't, that maybe the trooper wouldn't have arrested this defendant. But that's not because of anything that the trooper did. It's because of your client having that vehicle facing the wrong direction on an interstate.
I understand, but that trooper had an opportunity to deal with all that. Instead, he was ordered, told, move your car around. After that,
No, she did have the ability to deal with it, and she did.
right.
By telling him, turn your vehicle around.
And there was no investigation whether he was capable of doing that. No investigation whether he was drinking or not drinking. Nothing like that.
Well, which shows that the trooper did a good job because she didn't make any presumption whatsoever that he wasn't able to operate that vehicle.
Yeah, well, no arguing the court.
What?
Not arguing the court.
Oh, yes, you are, but it's okay.
Fine.
I mean, I get used to it, but here's the problem, Mr. Vincent. I get what you're arguing maybe, but that the driving or what was observed by the trooper, you're indicating was induced by law enforcement. I say, okay, maybe, except that you don't go back far enough, because if you go back far enough, the trooper encounters a vehicle pointed the wrong way on I-94 and then asks the driver. And at that point, according to her testimony, she's not presuming that he's intoxicated. She doesn't have any belief that he necessarily is. Tells him to turn the vehicle around. He turns the vehicle around, but then she notices certain signs that indicate to her that he may be intoxicated. And it's from that point that she begins her investigation into drunk driving.
The trooper had my client move the car out of a position of safety.
Yeah. Okay, go ahead.
That's my argument.
Yeah, I got you, but I'm not sure that
I'm
a
arguing with
vehicle facing the wrong direction on I-94 is a position of safety. I don't know. I mean, we'll take a look at that, but
anyways.
and the other thing is that you're also going to get into the definition of what constitutes a roadway, because it may very well be, and I'll take a look at it, that the shoulder constitutes the roadway also. I think by definition it does, but I will take a closer look at it.
Was it in the lane of traffic? I make that argument.
Right, but the statute talks about a roadway. Roadway under the, as I'm recalling it, I haven't looked at it. Roadway under the Motor Vehicle Code has a very specific definition, which may include those adjoining parts of the lanes of travel, which would be the shoulder. So it may be that it's in the roadway in any event, but I'll take a look. Okay, so thank you for the argument. How long is it going to take you to file your Frank's motion so that we can?
a couple, 3 weeks.
Seriously? Oh, I mean, okay.
Good.
2 weeks. Okay, I'll give you 2 weeks. What's the 24th? Yes. I need the Frank's motion by July 8th. The people's response to that, if necessary, by, I'm just going to give you 1 week. I don't think it's going to take long, by the 15th. And then I will set a hearing on that Frank's motion, which give me a Wednesday. That's,
I would give you July 29th.
well,
Would you like it before then?
I would.
July 22nd.
I can do it that day.
Yes.
All right. Then I'll hear the Frank's motion on July 22nd. And I will issue, if I don't issue it in writing beforehand, a decision on this motion. I'll just set a hearing date on that for July 22nd, but it's likely that I will issue a written in prior to that on this. Does that make sense?
Yes, just procedurally, because I think I was confused for this hearing. For the Frank's motion hearing date, does the court want to do an evidentiary hearing that date, or is that going to be set if necessary at a later date? I just don't want to bring the trooper back out again 2 times like I did this time.
Well, except that the preliminary inquiry on the Frank's hearing, while I could hear argument, the court can either typically make a determination that whatever the defendant claims is missing, not missing, whatever, that I could make a determination at that point that I still have probable cause, if you're following what I'm saying. So I'm not sure. I don't think we would necessarily need the trooper, because if the court makes that determination that there's not probable cause, then we would have to have a hearing, or that's something, because what Mr. Vincent argued, I'm not sure the trooper's testimony would be necessary. If there's something in that, and just so that it's clear, if there's something Mr. Vincent's claiming that is in that motion or in the affidavit that is untrue, and that the truth of that, well, it could be one of two things. He's claiming something is untrue. If it's untrue, and I say, okay, I'll give you the benefit of the doubt, it's untrue, but I still have probable cause, then I'm not going to need testimony. If, however, the validity of the search warrant would hinge on the truth or untruth of that statement, then I may need the testimony of the trooper.
Understood.
Okay, that's the only way that I can really answer that. Why? The trooper said she doesn't want to come back here? Is that what she said? Was she really critical of, like, it was Alan, wasn't it? That I get it. Okay.
My will be search warrant of 4 corners. So I'm trying to help the trooper not to have to come back, even though I know she's dying.
I know, no, you don't want her back because she doesn't really help you a lot. Just put it that way. I mean, she tells the truth, it just doesn't help you. I will make a determination if we need the trooper back. How about that?
Thank you.
And then we'll work around that. Anything else?
Nothing.
All right. Thank you. Thank you, trooper.
At 11 p.m. on a dark highway, a simple traffic stop turned into a courtroom moment filled with tension and unanswered questions. The trooper expected a routine encounter after finding a vehicle parked the wrong way. But what happened next revealed a much deeper situation. The driver's explanations, excuses, and attempts to avoid responsibility were carefully examined, but the courtroom was not about arguments, it was about accountability. As the facts came forward, the judge made it clear that confidence and excuses cannot replace the truth. With a firm approach and no patience for distractions, the court delivered a powerful reminder. Every decision on the road has consequences, and responsibility cannot be avoided forever.